This is the question pursued in chapters 7 through 10, which examine the development of American ideas on the issues that loomed largest in this debate: federalism, representation, the separation of powers, and rights. Answering these questions has given this book a somewhat complicated architecture, and readers are warned that I have found a measure of repetition unavoidable. Chapter 3, for example, is devoted to reconstructing James Madison's constitutional thinking in 1787 through 88, but I develop and elaborate these themes in every chapter that follows. Chapter 4 is similarly concerned with analyzing the politics of the Federal Convention, but succeeding chapters return to Philadelphia in 1787 to explore how the framers approached particular issues. These questions, and others, can be pursued at many levels of generality and with widely varying results. This is an enormous field and a subject of continuing inquiry, and I make no pretense of resolving its major theoretical problems, much less all the issues that American law and politics repeatedly generate. This book is an interpretation of the origins of the Constitution. It is selective in the topics it pursues and in the approach it takes. It attempts to identify the great sources of contention, but it does not address many of the lesser and some major questions that were also in dispute. I have tried to give the anti-federalists their due by allowing their most trenchant objections to the Constitution to lay a foundation for the response they elicited from their Federalist opponents. In sketching that response, I have been surprised to discover how much emphasis I have given to the Federalist. The reason for this is the obvious one. Nothing equals it in analytical breadth and conceptual power. Yet how one thinks about its 85 essays, in relation both to the private concerns of the two principal authors and to other Federalist writings of 1787 through 88, remains a critical problem to which later chapters repeatedly return. Early in this project, I considered examining some of the constitutional issues that have been agitated in recent years, but which the framers and ratifiers either ignored or considered only fleetingly or obviously could not foresee. Many of these issues can still be analyzed from an originalist perspective, and more or less plausible inferences can be drawn from the evidence of the 1780s. But the longer I pursued this project, the less enticing such questions became. It is hard enough for a working historian to keep up with all the constitutional questions that American law and politics repeatedly, and often surprisingly, bring before us. Shaping this narrative to take account of such questions would give this book a presentist skewing that would detract from its purpose of explaining how a national polity was in fact created. Equally important, because I firmly believe that the framers and many of the ratifiers were themselves decidedly empirical in their approach to politics, it seems rather beside the point to ask how they would act today. Whatever else we might say about their intentions and understandings, this at least seems clear. They would not have denied themselves the benefit of testing their original ideas and hopes against the intervening experience that we have accrued since 1789. Footnote: I'm often asked whether I think originalism offers a viable or valid theory of constitutional interpretation. My preferred answer is, I hope, suitably ambivalent. In the abstract, I think that originalism is vulnerable to two powerful criticisms. First, it is always in some fundamental sense anti-democratic, in that it seeks to subordinate the judgment of present generations to the wisdom of their distant political ancestors. Second, the real problems of reconstructing coherent intentions and understandings from the evidence of history raise serious questions about the capacity of originalist forays to yield the definitive conclusions that the advocates of this theory claim to find. On the other hand, I happen to like originalist arguments when the weight of the evidence seems to support the constitutional outcomes I favor, and that may be as good a clue to the appeal of originalism as any other. Rather than attempt to resolve pressing problems of current controversy, therefore, I have sought to present a contextually grounded account of how the Constitution was drafted and ratified that will give those seeking to ascertain original meanings a more informed basis for considering what the entire process of its adoption entailed. That, in part, explains why I pay particular attention to James Madison.